This meeting of the Escambia County Board of Adjustment, September 28, 2022, is hereby called to order with 5 members present. We have a quorum. Will the clerk please swear in members of staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of staff resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The Board of Adjustment meeting package of September 28, 2022 with the Development Services staff's findings of fact has previously been provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence.
Motion.
Do we have a motion?
Motion.
Motion by Willie. Do we have a second?
Second.
Second by Marty. Those in favor signify by raising your right hand. The motion passes unanimously. Do we have proof of publication?
Yes, sir.
Did the publication meet all legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of the legal advertisement. Do we have a motion?
Motion.
Have a motion by Willie. Do we have a second?
Second.
Second by Marty. Those in favor signify by raising your right hand. Passes unanimously. Members of the board, have you reviewed the resume and transcript for the Board of Adjustment meeting held on July 20, 2022? The chair will now entertain a motion regarding the reading of the resume of the Board of Adjustment meeting held on the previous date of July 2022. Do we have a motion?
Motion.
Motion by Willie. We have a second.
Second.
Second by Marty. Those in favor signify by raising your right hand. Motion passes unanimously. The Board of Adjustment, or BOA, hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing statements will be limited to the evidence in the record. After hearing the testimony and arguments against or for the proposed action and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because the decisions of the BOA relating to variances, conditional uses, and extensions of development order for the plan approval is final, unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside, the development order or permit may be revoked, or the development may be otherwise enjoined from the reviewing court. Any applicant for relief from a decision of the BOA for said actions or any aggrieved part as defined by state law may seek review of such decision by filing an appropriate pleading in court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision will be the date the BOA voted at the conclusion of the hearing, and the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may, within 15 days thereafter, apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk. These forms are located on the table in the back of the room. You will not be allowed to speak until we receive these completed request forms. We must have these completed forms for our public record. All written and oral communication outside of this hearing with the members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission Resolution 96-13 before a decision by the board on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the communication. The first case to be heard is conditional use 2022-12, 9722 Highway 98 West. Board members, has there been any ex parte communication regarding this case? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium, identify yourselves, please state your name and address for the record, and wait to be sworn in by the clerk.
Good morning, Chair. My name is Meredith Bush. I'm an attorney with Clark Partington,
Okay.
125 East Intendencia, here with the applicant, Mr. John Truskowski.
Okay, and if you'll, only you need to be sworn in, sir.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
And were you provided with a copy of the staff's findings of fact?
Yes, sir.
Since it was approved, I assume you concur with it, and if so, with your permission, we'll go ahead and let the county present their case, and then if you have any questions or comments, we'll address you then.
Absolutely, we do concur and happy to let them proceed.
Thank you.
Ready? Okay. All right, this is conditional use 2022-12. This is a location map. This is the 500-foot radius zoning map showing the zoning on site is commercial. Future land use for the site is mixed use suburban. This is an aerial map of the site. This is the public hearing sign that was posted on site. This is looking north onto the subject property from Highway 98. Different angle there, looking northeast into the property. northwest into the property. As to the findings, this is conditional use request to allow operation of a bar in commercial zoning. I'll go ahead and go through the findings for you. The first criteria is dealing with general compatibility. Based on information available from the Escambia County Property Appraiser, the building on site was built in 1980 and predates the Land Development Code. The building has housed multiple commercial uses since construction and is currently in use as a restaurant. An aerial photograph from 1980 shows that most of the nearby residential uses were vacant lots at that time. The proposed change in operation from restaurant to a bar will not change the basic nature of operations or the hours of operation. Second criteria, dealing with facilities and services. Potable water, sanitary sewer, and solid waste disposal are all in use with the current restaurant. Third criteria, circulation. Access and parking lot will not be changed as part of this request. Fourth, nuisances and hazards. The proposed use should not generate unreasonable noise, glare, dust, smoke, odor, vibration, electrical interference, or other nuisances or hazards for adjoining properties and other properties in the immediate area. Fifth, solid waste. Solid waste services are currently provided to the restaurant operation. Sixth, screening and buffering. Screening and buffering will not be required between this use and the adjoining property. Again, buffering is between residential and commercial uses or zoning districts. In this case, you've got commercial up against commercial. Signs and lighting. Any proposed change in signage will require review for permitting. As you can see in the photos, there is currently a sign on site that has been there for quite some time. Site characteristics. The site is adequate for the proposed use to be operated in a similar manner to the current use. Specific use requirements. The change in alcohol license type will require sign-off from county planning staff. And as to the findings, staff recommends that the board approve the proposed conditional use as requested. And I don't know if we have any speakers signed up.
Okay. Board members, any questions of staff?
I just want to clarify, the reason they're here is because the restaurant is now becoming a bar.
So there's different alcohol license types through the
Right.
state. And I believe it comes down to a percentage of sales as far as what's food and what's alcohol.
Right,
And if they were to go over that percentage, then they would need the licenses of bars. So they're going ahead and, they can still serve food as a restaurant.
right.
This just comes down to the specific percentage.
And I had read in there somewhere, if the conditional use goes through and they classify themselves as a bar, they could essentially be a packaged liquor store, if you will.
So that's a different type of license. Again, a separate kind of license that would require review through us. I don't think there would be an issue there because of the distance requirements from churches, schools, and daycares,
Right.
which will of course be reviewed again, it does every time someone comes in and changes a license type.
I guess this is a question for them. I'm trying to understand what is their intent in this change.
Would you like me to address that? Good morning. Yes, ma'am, thank you for your question. So really, the only difference will be that right now as a restaurant, 51% of the sales, greater than half, needs to come from food. Because of a shortage of kitchen labor and staff, they're wanting to remove that 51% requirement. They actually already have the correct licensing. There's no intent to be a package store. There's no intent to change the intensity of the operation. Hours of operation won't change. There'll be no difference except for the fact that instead of having to have a full kitchen staff to run a restaurant menu, they'll be able to serve, and they'll still serve food, it'll just be more bar-type food with like 2 members in the kitchen to serve. One other thing, although the buffering requirement is not there per the staff's findings, there is an intent of the owner to install a privacy fence along the east side of the property. Also in our submittal, we included photographs showing the rear of the property that shows some existing very thick wooded vegetative buffering. So if you'd like to see that, staff could bring that up. I'm happy to walk through the other criteria, but again, we meet everything that the code requires.
Is there any new development gonna be on the property besides that fence that you discussed?
No, there'll be no new construction, no modifications, no new development.
Okay. That's all I got.
I have a question.
Yes, sir.
If I recall last night reading this submittal, on page 6 of your application, there was figures that outline the makeup of the area that we're talking about. And if I recall, 73% or some number in the 70s is primarily residential. Am I correct in that?
So on page 6, what that is the mixed-use suburban flu, and what it requires, the 70% residential you're referring to is areas beyond a quarter of a mile away from arterial roadways or transit corridors. Then the following mix of land uses is anticipated to include 70 to 85% residential. So that's straight out of your comprehensive plan.
Right, and, so, the area around, I realize this is on Highway 98, which is a busy, major arterial road, I understand that point. But around it are quite a few of, residential developments, am I correct in that?
Correct. So this commercial development predates that existing residential, and we would be within a quarter mile of that arterial roadway.
And also,
So the intent would be that further out away from the main highways, you would have residential according to the comprehensive plan.
and, also, if I understand correctly, should this designation be, accepted and approved by the board, then if this restaurant, if the owner should decide one day he wants to retire or do something else, he could sell his property and this designation would go with the new owner. Am I right in that?
That is correct. So, the use would remain. If at any point, though, that new owner wanted to come in to do something different, greater in scope or intensity than what they're offering, it would have to go through the change of use process, which is through the Development Review Committee and through county review. So if, say, for instance, I know I've heard package store mentioned, if somebody wanted to come in and do something different, which a store, a retail store would be different than a bar that serves alcohol and food, it would have to go through the change of use process with county staff.
And, from what I understand, the testimony is that, there aren't any plans for, outdoor, a patio, or any kind of fan shell, or anything along those lines, am I right?
Correct. There are no plans to modify or change the existing operations. It's all indoor seating. No plans to have loud music at night outside or anything like that.
And let me add to that, and I don't want the applicant to basically pigeonhole themselves. If there is a possibility, whatever, they still have to come back to us, because when you have the outside entertainment, that requires another review from the county to make sure that you meet the right zoning and those other things. So there are other reviews for other uses that with outdoor storage and entertainment that our zoning land development code specifically address. And if that does occur, there are protocols in place. It's just not automatically that they have to go through. I just want to be clear on that. So it's the protections are there, but they say they're going to do that. But if a potential buyer may want to do something different, there's a completely different process that is in place that they have to go through. It's not known yes automatically.
Mr. Chairman, I've got a couple of questions for staff on the findings. Thank you. Can we go back to the on A, is it relevant to our decision today that, this building was built in 1980 and predates LDC?
So what I did there in that first one is give you, because, excuse me, that criteria is dealing with general compatibility. What I did was give you the history on it so you can see why there is a commercial operation where it is. And when you look at the overall, you will see that there are residential uses on essentially three sides. I mean, this has a larger parcel that essentially covers around it, but beyond that, there are residential uses. What I was giving you there was the background on it so you would understand there was commercial use there prior to land development regulations and prior to the infill by most of those residential uses. So compatibility with the surrounding residential uses, a lot of those uses moved to this area. It's not like they're bringing a commercial use to the residential, it's the other way around.
Is that fact or
Yes.
facts relevant to the decision that we have to make? It would be as if this is an entirely new use. It's not, doesn't really have anything to do with what exists in a way.
So the change in license type is a use change. The general nature of the operation is not. The general nature of having a commercial operation in this area with quite a bit of residential around it predated the vast majority of the residential. This property was rezoned a while back, I can't remember, a year or two ago, and that was some of the concerns that came from the neighboring area of, why would you allow a commercial use next to these houses? Well, that use was there before the houses. They were just changing the zoning.
And the staff has determined that this change in use, to my way of thinking, a restaurant is not the same sort of operation as operating a bar. This change would not be a potential nuisance to the neighborhood it's basically a good deal of it is surrounded by homes.
Woods first, woods and a lake, and then homes, and a commercial operation to the east. They're not changing the layout of the parking lot. They're not changing their hours of operation. They're not altering the building. They're not adding outdoor operations. the same operation that's going on now is what they're proposing. It's a change in license type, and as their agent explained, a change in their operation as far as percentage that's food, as far as alcohol sales. Externally, it's not a change. The internal percentages are what's changing.
Lastly, have you heard from the neighbors in the area?
I anticipated quite a few phone calls. I have not gotten any. I don't know if any other staff have.
We have not, I asked that question yesterday. We have not, particularly with these type of uses, if there's some major concerns, the neighborhoods will, especially, they would receive notification within that, because they right there. So I have not, and I asked my staff yesterday, no phone calls, none whatsoever. Now, that don't mean that they may not come afterward, but right now, yeah, you can see, none.
Okay.
And if I just may clarify, the existing restaurant currently serves alcohol, so it's not a change to add the alcohol, it's simply removing that 51% requirement. I believe that at the time of the rezoning, some of the neighbors who may have expressed concerns, that's been alleviated by the fact that the business is operating peacefully. There's been no conflict. If you'll pull up the photographs showing the buffering between those residential and the property, it's very well wooded, and again, they're willing to voluntarily plan to install an 8-foot privacy fence along that eastern boundary separating the residential neighborhood. Happy to address any other potential impacts.
How did this issue come about?
Again, it's due to shortage of kitchen staff.
Yeah, but I mean, how did they know, hey, I need to look into this? What prompted them? Was it?
Probably conversations with me, to be quite frank. We had dealt with them prior to, through the rezoning process, and just and I'm happy to call Mr. Truskowski up here to address it. You know, he may can speak better than I can to his, intent when contacted me to make the change, but to
I just
go
didn't know if
from-
this was like a sales tax Florida state thing that said, hey, you're not zoned properly.
No,
or-
there's been no compliance issues, there's been nothing like that.
Okay.
Would the applicant be agreeable, should this be approved by the board, that as a condition of its approval, that privacy fence be constructed?
Sure.
Okay.
Again, that's not a requirement of the county, it's something that they would like to do for their own purposes, but yes, absolutely.
Yes, matter of fact, we've already started, matter of fact, today, we're gonna start that process. And it was something I wanted to do anyway, because we're having stray dogs come over from that area, so I'm trying to block that out. But it was something we're getting ready to start as of today.
And I would like to say this, and that is lessen any impacts. Fencing with that, on a commercial property with that is trying to be in harmony with the neighbors, especially with that extensive buffer there. Staff is very, very glad for that, because we see so many people that need to improve their property, and fencing would help, and many commercial businesses do not. But for this to make a recommendation for this, they want to do that, that's very, very well spoken of by them, want to be in harmony with the surrounding properties.
How long has the restaurant, if you will, operation been in business?
So, I let, yeah, yeah, do the,
We have actually been in operation sometime around December of this previous year. But I also own 6 other entities of bar and restaurants here in Escambia
Right.
County.
So it's been in operation as I'm sorry, I don't have the name of the restaurant, but it's been in operation as the Moonshine Grill and Still since December.
Yes.
Okay.
And I believe prior to their ownership, it was a pre-existing restaurant as well.
Okay, we have a couple of speakers. Speakers, limit your speaking to 3 minutes. And if you will, when you introduce yourself and are sworn, just state whether you're for or against the conditional use, and then give your summary. The first one is, I believe that is John Trokowski. Oh, okay, John. You're already sworn.
Yes, sir. Again, I'm for, of course, but the thing with us, you know, I've already had to close one of my entities down on the beach because of the same issue. And what's happening for us is, in order to keep that percentage up, I'm having to serve the seafood to keep that percentage up where it needs to be. But right now, I'm actually in the process of losing. Food costs went up. People are not willing to pay $80 for an all-you-can-eat seafood, which we're happening to be in that range in order to keep the doors open at the percentage we're at right now. And so that's why I'm looking for another alternative, less amount of food, and it allows us to serve something that would be more comparable with the area. We get a lot of complaints on the price, and so that drives a lot of the customers away.
Thank you, sir. Board, any questions of the speaker? Seeing none. Renee Henry is for the project but does not desire to speak. The minutes will note that. David Vanderling.
That's for another case.
Oh, I'm sorry.
I think that's all the speakers we had for this case.
Sorry. Okay, I believe that's all we have. Any other speakers for this conditional use on 2022-12? Not. Board members, any questions of the staff or the applicant? Seeing none. The chair will now entertain a motion regarding this item. In your motion, please state whether you do or not adopt the staff's findings of fact. If for any reason you do not accept staff's findings of fact, please go to all the criteria and address each one specifically as to why you do not find staff's findings. Do we have a motion?
Mr. Chairman, I'll move that the board approve the application with a proviso that a privacy fence be constructed that will shield the adjoining neighborhoods from this establishment.
We have a motion by Michael with a condition. Do we have a second?
Second.
Just to clarify, is the fence gonna be on both sides of the property or one side?
Well, I own the property to the left that shields them the other property now, and it's gonna be on the right side.
It's gonna be on the right, oh, it's gonna be on the right side. You wanna clarify that motion? Or stand? Basically what he's saying is, privacy fence has to be on both sides.
Yeah.
But-
Let's look at that map again.
Look at the map, that's what I was gonna look at the map. Let's look at the map, there you go.
All right, and the applicant's proposed fence would be, if you could use your cursor, along there, along that side.
All the way back, out on the property behind it, it's gonna go all the way back.
Put it down, Rachel.
That's the east side, that's the east side? Yeah.
What about the property, do you own, could we go back to the map again? The property to the left that's heavily wooded,
I own that, yes, sir.
So that's one parcel, the property that you see, the woods to the west, the lake to the north, and the trees along the drive aisle to the east. That's all one parcel of land that is owned by the same owner.
And what is the zoning of that property?
It's commercial as well.
Okay. Yes, I would ask that it be on would that be our east side? Yeah.
So east side only, or, okay. Because see, the reason why, what you see with the heavily vegetation, area, we would really want that vegetation to remain, because when you start putting the fencing up there on that side there, you got that, I'm assuming that's some type of lake or pond or something.
Yeah, there's 2 lakes back.
Yes, I would not want staff, because of our profession that we are in, when you start removing vegetation like that, it causes so many other problems. That vegetation is thick and is good. And it needs
I
to
think
remain.
that lake is a natural barrier.
Yes, sir.
I'm not so very concerned about it. I am concerned about the other side though.
Yes.
That would, Mr. Chairman, that would be my motion, finally. That as a part of granting this application, that there be a privacy fence constructed on the east side of the property, which will shield it from, the area, from the activities, the homes, the facilities that are to the east.
Could you amend that to say the east side of the owner's property?
Yeah, the owner's property.
Thank you.
I'm sure he's not gonna build it on anybody else's, but,
Well, because this parcel that the building is on is encompassed by his other parcel.
Right.
Putting it on the
Absolutely.
east side of this particular parcel would run it right down the middle of the parking lot. That's why I'm saying,
okay.
Right. And I would like to add, and also too, which as staff, we gotta have land use approval for that. If it's not conducive, whether there's some wetlands or any of those other issues, and that may impact those ponds going that far up, it's gonna be contingent upon really staff gonna have to really review that, because I don't wanna impact wetlands, and then we can't do that, even with fencing and drainage and stuff like that. So we need to let staff review it, and if it's available, when they come in with the site plan, we would definitely get it done under staff review. That's
Okay,
critical.
we have a motion, with a condition. Do we have a second? Willie, seconded. Do you okay with the additional condition?
Most definitely. Yes, sir. Second.
We have a motion, we have a second. Is there any further discussion? Seeing none, those in favor signify by raising your right hand. Passes unanimously.
Thank you, sir.
The next conditional use case is CU 2022-13, 9900 block of Guide Lane. Board members, has there been any ex parte communication regarding this case? Seeing none, does anyone have knowledge or or information obtained from a site visit or other sources?
Chairman, I just wanted to say, this is my route going home. I go down Guide every day. I just wanted to clarify, I don't live in the 500-foot radius or anything, but I just travel that path daily, so I'm familiar with the site.
Okay. We okay with that, Counselor? Does any board member intend to refrain from voting due to a voting conflict of interest? Council has advised it's not a voting conflict. The parties are here, and if you'll state your name and address, be sworn in.
My name is Kenneth Ogle, 6901A North 9th Avenue, Pensacola, Florida.
Please raise your right hand.
Thank you, sir.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And were you provided with a copy of staff's findings of fact?
I was.
And I'm assuming that you agree to them since it's all approval of all the criteria. And so if you agree, we will go ahead and proceed with staff's presentation so we'll all have it fresh.
I do agree.
If you'll have a seat, we'll give you a chance to speak later.
Thank you.
Yes, sir. Conditional use case 2022-13. This is the location map. The 500-foot radius map showing the zoning is medium density residential. Future land use map for the site is mixed use urban. And this is an aerial map of the site. This is the public hearing sign. This is looking east across Guide to the property. Once again, looking east and looking northeast. That's just looking south along Guide. You can see the public hearing sign posted on the site. This request in medium density residential is for townhomes. And just to get everybody up on speed on this, townhomes are different than other operations that may look quite the same. With a townhome, you are subdividing the land. It does have to go through the subdivision process, but the land use approval requires conditional use in that district because this did not have a previous zoning that allowed for that. So I will go ahead and go to the staff findings. They're in here somewhere.
Each home is individually owned, is that?
Yes, yes. All right, staff findings. First criteria, dealing with general compatibility. The subject parcel is in an area of mixed residential uses, many of which predate the Land Development Code. The mixture includes single-family residences, duplexes, and apartments. Changing this parcel from a vacant single-family use to townhomes will be compatible with the existing residential mixture. Facilities and services, potable water, sanitary sewer, and solid waste disposal are all available to the site, and the necessary infrastructure will be included as part of the construction plans. Circulation. As described by the applicant and reflected on the site plan, the proposed lots will each have a driveway connection to a proposed public right-of-way connecting to Guide Lane. Nuisances and hazards. The proposed use should not generate unreasonable noise, glare, dust, smoke, odor, vibration, electrical interference, or other nuisances or hazards for adjoining properties and other properties in the immediate area. Solid waste. Solid waste services will be provided to the site as required for the residential use. Screening and buffering. Screening and buffering will not be required between this use and adjoining uses. Signs and lighting. Proposed signage and lighting will be assessed during site plan review. Lighting should be directed inward to avoid impacts on the adjoining adjacent properties. Site characteristics. The site plan appears to show a development suited to the parcel characteristics. Some layout revisions may be required as the project goes through development review regarding pond and access conditions. Any specific use requirements? The MDR zoning district does allow for zero lot line in certain multifamily dwellings if the previous zoning was R3, but the previous zoning for this parcel was R2, necessitating the conditional use request. Findings, staff recommends that the board approve the conditional use as requested. Now, should this board approve that conditional use, the next steps that will come through, because this land will be subdivided, when they go through development review, they will have to go through a preliminary plat, which will give them the general layout of the land and the maximum number of lots that would be allowed. They would follow that up with construction plans, which then allow for the construction of the infrastructure, putting in the road, putting in the stormwater system, adding the utilities. From that, they would go to final plat process, in which the final layout of the land will be approved by the county commission. I did note in here that their initial layout is subject to change somewhat, once they go through the preliminary plat and construction plan phase. We often see some revisions to that. Let's say an extra easement needs to be put in for some sort of stormwater feature. They may lose a lot, or they may have to shift those lines around and change it slightly. At this point, the plan that you have in front of you is just a general layout for the land use approval.
I have some questions. What is the density allowed in the MDR?
I can look that up. 10? Let me double check, y'all. Let me double check. Maximum density of 10 dwelling units per acre.
And how many acres is the site?
Let me see. 2? It's just over, I think. Or just under. Let's see. We would need you to speak to the microphone, sorry. Property appraiser says 1.96, so 2, and round it.
So the most that we would put in there would be 20, and that would be,
Yes.
yeah, and of course, that will be subject to soil testing and approvals on reclamation pond, et cetera. So,
And will this be on sewer or septic?
sewer.
Sewer. What is to the north of this site?
That is a duplex development. The lot is almost exactly the same as this one. It's like a sister lot. At some
That's
point,
right.
they did get R3, and so that permitted them to put in duplex units. I believe there's 8 duplexes, so 16 livable units in there. So, now,
And-
go ahead.
That you see that aerial at the, I guess it would be the east end? What is that? That dark area, is that just an open area, or is there actually a pond, or?
Yeah, yes, ma'am, that's a reclamation pond.
Oh, it is a pond already? Okay. Okay, because I knew there was some drainage issues in this particular area, and,
That lot is lower than our lot,
Right.
so we will not have the same drainage problems that they have. So, based on the soil topography. So,
okay. All right, thank you.
I have a question also. What, are those warehouses that are below, or?
So that building is currently vacant, and it's got a sign out that it was a church, but it's
Okay.
currently a vacant building.
And on farther over, then I take those are those homes?
Single-family residences, yes.
Right. Okay.
Once again, townhomes are a single-family residence as well.
if I may, also those properties to the south are zoned HDMU.
I'm sorry, I didn't hear you.
The properties to the south there, that's all zoned, along Requin, that's Requin Lane there. If you go back, yeah, I see Requin, so that's all zoned HDMU there.
Okay.
So it would lend that we are in accord with the overall plan of the community. Thank you.
Board members, any questions of the staff or the applicant?
Mr.
I show
Chairman,
no speakers other than those who have appeared.
well, Mr. Chairman, we certainly need more housing. How large are these going to be, estimated, square footage?
Yes, sir. The estimate is approximately 1,600 square feet, 3-bedroom, 2.5 bath, 1-car garage with additional parking on the property.
Okay,
And
so
I
these are
do-
gonna be fairly large.
As far as the townhome goes, they'll certainly be sufficient for a family, which is my desire. I'm hoping to put in affordable family housing that will be an asset to the neighborhood that people can be proud of. Otherwise, I don't want to be involved, so, if that means anything.
Any other questions, board members? Chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's finding of fact, please go through the criteria and address each one specifically as why you do not. Do we have a motion?
Motion, adopting, staff's findings of facts.
We have a motion by Willie. Do we have a second?
Mr. Chairman, I'll second it. This looks like the
We have a second.
kind of project that we need, and
We have a second by Michael. Is there any further discussion? Seeing none, those in favor signify by raising your right hand. Passes unanimously. The next item is conditional use 2022-14, 1008 North Navy Boulevard. Board members, has there been any ex parte communication regarding this case? Seeing none, does anyone have knowledge or information obtained from a site visit or other sources? Seeing none. Would the individuals who are party to this item please come to the podium, identify yourself at this time. Please state your name and address for the record and be sworn in by the clerk.
So my name is David Vanderlyk. My son is on the petition. He got unexpectedly called. He's a merchant marine, and they called him to the ship, so he's not present. So I'm hoping that the board will allow me to.
Let's be sworn.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And do you want to,
Danny is the muralist, and so
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
you were presented with staff's findings of fact.
we were.
You concur with them.
Yes, sir.
There, we'll then move to a presentation from the county, if it's okay with you, and then you'll be given any opportunity you need to speak. Thank you. Staff?
Good morning, Board. Caleb McCarty, AICP, Escambia County. Here we have our location map off of Navy Boulevard. The next slide, we have our 500-foot radius zoning map. The zoning is commercial. And we have our future land use designation as commercial as well. It is in a CRA district of Warrington. And this is the aerial map showing the buildings on the property. Next, we have our public hearing sign. It's been posted on the property. This is looking east onto the subject property. The proposed mural will actually be going on that right building. We do have a sketch to show momentarily. This is looking at the adjacent property to the south. This is looking north along Navy Boulevard. Substantial right-of-way there, as you see, along Navy. And this is looking northwest across Navy towards commercial development. Looking southwest along Navy again, and this is looking west across Navy Boulevard. This is the proposed mural. There are two buildings on the property that have existed for a long time. The proposal is what you see there on the right. It's approximately 314 square foot on that side of the building. If you like, I can go into staff's findings at this time. So the applicant is requesting conditional use approval for a mural sign. What's important here is the relevant authority murals, when they go over a maximum 200 square feet and they're going to be on the primary facade, we treat them as wall signs. So this exceeds our wall sign calculation, so therefore triggers a conditional use per section 5-8.6 D9. Concerning criterion A, general compatibility, we found that the current use of the building as a video production facility, the maximum wall frontage is 2.5 square feet per linear foot of building frontage at grade, as this building faces an arterial street. The building at grade is 40 foot in width, resulting in a maximum wall signage of 100 square feet. The applicant is proposing the 314 foot square foot mural sign on the front building facade. The proposal exceeds the wall signage allowance for the building in a manner of use, resulting in conditional use request. The applicant did provide visual aids to reflect the overall size and appearance of the proposed mural sign. The area is highly commercial, containing multiple wall, freestanding, and billboard structures located in the general vicinity. Per section 3-3.8A, the intent of the Warrington overlay is met as this proposal enhances the character of an area undergoing revitalization, especially those along commercial corridors that provide primary access or gateways to the adjoining military installations within Warrington area. Based on this morning documentation and a site visit to the area, the appearance of the proposed mural sign will be compatible with the overall commercial character of the adjacent properties and other properties in the immediate area. Concerning criterion B, facilities and service, we found that they are established for the existing building, yet are not required for the proposed mural, of course. Criterion C, concerning on-site circulation, we found that this would not have an impact on on-site circulation, egress or ingress. The request does not have an impact on pedestrian safety or convenience that we found. And the mural sign would not affect traffic flow, on-site parking, loading, or emergency vehicle access. Criterion D, concerning nuisance and hazards. We found that the request for a mural sign does not influence the scale, intensity, or operations of adjoining properties, and we found that it did not generate any nuisance for adjacent properties. Concerning criterion E, solid waste, the requested mural sign does not influence any aspects of solid waste, we found. For criterion F, screening and buffering, the request for a mural sign does not have an impact on screening and buffering requirements, would otherwise not be required. And criterion G, signs and lighting. The proposed mural sign as submitted by the applicant will be compatible with the commercial character of the adjoining immediate properties in the area. The area is highly commercial with a variety of signage types found in the vicinity. No glare or traffic safety concerns are anticipated by the proposal. No lighting is proposed for the project. If there is any lighting proposed for the mural sign later, current land development code requirements will apply during the review for compatibility with the surrounding area. Concerning criteria H, site characteristics, the proposed mural sign does not modify the existing uses for the site. The proposed mural, as presented by the applicant, appears to be aesthetically pleasing and compatible with other existing commercial signs in the area. And then finally, criterion I, the use requirements. We found that per, again, section 3-3.8E9, the Warrington CR requirements for signage say that wall signs shall not be shall not obstruct design details, windows, or cornices of the building to which they are attached. Per an email received on 9/12 from Matt Rogers, he is the Development Program Manager for the Warrenton Community Redevelopment Area District. They have no objection to proceed with, for the proposed mural. That's just saying the CRA didn't have an issue with it. We found that the proposed mural sign complies with the additional use requirements of the LDC. And finally, staff recommends that the board approve the conditional use as requested. That concludes our findings.
Thank you.
Yes.
Board members, any questions of staff?
Just to clarify, we are, the conditional use is based on the size of the mural, or is it based on the fact that it's a mural and the size?
Yeah, and you're kind of correct on both of those. Whenever it exceeds a maximum of 200 square foot and it is going on the primary facade, it triggers the conditional use. That's what puts us here. We had one of these probably 5 or 6 years ago, very similar. So it's saying that you can exceed it and you can put it on the primary facade as long as you go through this process. So.
What if it was on the side of the building and it
Yep.
was within the 200?
You're
Then you wouldn't have
you wouldn't need
needed.
to be here. That's
Okay.
right. That's correct.
The last one was the neighborhood Walmart on 9 Mile Road,
That's right.
if y'all remember.
What makes this a mural and not a sign?
This
We-
is, that's an interesting point. We found that murals are treated as wall signs. So we just kind of take it as, okay, a proposal for a wall sign. And when we use the calculations, that's why those calculations are provided in the findings. And obviously, they're treated as such. Now, I think the difference here, and Mr. Homer can correct me if I'm wrong, I don't believe that this would otherwise require an additional building permit. I believe it's just an authorization through this process that would authorize the land use and actual painting. Obviously, if it's a wall sign like we've dealt with in the past, approval here would allow them to continue the building permit process. But I think this is simply the authorization of the painting on the wall. So, but it is defined as a wall sign, and the calculations and the manner of use, the primary facade, treats it as such. I think I answered it.
All signage is content neutral. The only permitting this requires is just this particular land use. Our land development code defines a mural. It says a mural is any sign that is an original, one-of-a-kind work of visual art, tiled or painted by hand directly upon the facade of a building. It's straight up. It's original artwork that is counted, though, as signage, because once again, all signage is content neutral.
Board members, any further questions of the staff? Any questions of the applicant? Applicant, do you have any questions of the staff or the board? If not, the chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If not, for any reason you do not accept staff's findings, please go through all the criteria and address each one specifically as to why you do not concur. Do we have a motion?
Motion to approve according to staff findings.
We have a motion by Willie. Do we have a second?
Second.
We have a second by Marty. Any discussion? Those in favor signify by raising your right hand. Passes unanimously.
Can I just say something right quick? Since there's nobody following me, it's not pertinent, it's just, I'm a naval aviator, retired naval aviator, the vision of the hands is the way aviators speak to each other, but the model for the hands was from our good friend Nick Pace, who passed away at 102 this year, World War II Hellcat pilot, who is also the inspiration for our company name. I just thought that was perfect for you guys.
Thank you.
Thank you so much.
I
Thank
was
you.
wondering about that. Thanks. Good luck.
The next meeting is October 19th, I believe.
Yes, sir, and we only have one conditional use case for that
We
meeting.
have one.
And Kristen will actually be doing a presentation that day as well, and that'll be it.
Thank you. Counselor, you have anything for us? Okay. Without objection, we stand adjourned.